Sovereignty is regarded as an essential element of the state as it is the exclusive right to exercise supreme political authority, whether legislative, executive, or judicial, over a geographic region. The term sovereignty is derived from the Latin word superinus, meaning supreme. So, in the present context, sovereignty refers to the supremacy or supreme power of the state. Sovereignty is primarily a legal concept, as it has been defined as that characteristic of the state by virtue of which it cannot be legally bound except by its own will or limited by any other power than itself. The basic idea is that the sovereign, be it a monarch or a chief executive or an assembly, they are able to declare law, issue commands, and take political decisions which are binding on all individuals and associations within its jurisdiction. And also the sovereign commands physical force to punish those who ignore or disobey his orders or decisions. In fact, it is the concept of sovereignty that arms the state with supreme legal authority in both internal as well as external affairs. As internally, it establishes supremacy of the state over all individuals and associations as well as the territory under its control. And externally, it upholds independence of the state from the control or interference of any other state or any other agencies in the conduct of international relations, whether it be United Nations or any other international organization. Therefore, each sovereign state is equal to every other in international relations and international law, regardless of its population, area, or economic resources. Even the United Nations Charter states that United Nations is based on the principle of sovereign equality of all its members. And since the concept of sovereignty attributes supreme power to the will of the sovereign, it is by nature an absolute, unlimited, and perpetual power. See, this may, however, not be interpreted as an arbitrary power, because the absolute power implied by sovereignty is not intended to be exercised without reason, or without invoking one's sense of justice, or without giving regard to any prevalent customs, values, ideals, or even the necessity of the common interest or public interest. Therefore, due regard to all these factors has to be given, otherwise the legitimacy and authority of the sovereign power will be rapidly eroded and sovereignty may eventually be lost. So the idea behind absolute nature of sovereignty is that, legally speaking, the sovereign is not obliged to consult or seek the approval of any other individual or group whether a particular decision, command, or law is right or wrong. Therefore, he is empowered to decide all such issues at his own will and discretion, and his decisions will be binding on all unless he himself chooses to revoke them. Let's discuss some of the characteristics of sovereignty. Firstly, the absoluteness. So, sovereignty is regarded as absolute because it cannot be limited or restricted by any superior power or authority, and the will of the sovereign reigns supreme in the state. Therefore, the sovereign may, of his own will, pay due regard to moral principles, customs, traditions, or even the public opinion. But he is not responsible to any authority, whether be individual or group, similar or superior to himself. So similarly, the sovereign may pay due regard to international law by his free consent, and not because he is obliged to obey the commands of any superior state or international organization. The second characteristic of sovereignty is permanence. So in order to understand the permanence of sovereignty, it is necessary to distinguish between the state and the government. See, sovereignty belongs to the state and not to the government, because the governments may be formed or dissolved according to the established procedures, but the continuity of the state will not be affected by such changes. So sovereignty endures as long as the state maintains its independence. And if a state loses its independence and is placed under another state, its sovereignty is ultimately lost. Therefore, as long as the state continues, so does the sovereignty, and the change of a government or death of a ruler does not mean an end of sovereignty. Another characteristic is universality. So sovereignty is a universal, all-pervasive and all-comprehensive quality in the sense that it extends to all individuals, groups, areas and things within the jurisdiction of the state. So if a state grants immunity to any category of person, especially foreign heads of the states, UN officials, or like foreign ambassadors, their staffs, residents, etc., it is because of its free consent and not because of any external obligation or restriction. Basically, it is a matter of international courtesy and not of compulsion. So this concession can be withdrawn at any moment at the will of the sovereign. Therefore, international associations and multinational corporations operating within the territories of different states are also subject to the sovereignty of the respective states. The next characteristic is inalienability. So, as an essential element of the state, sovereignty cannot be transferred or given away without destroying the state itself. See, as when a state cedes a portion of its territory to another state, the ceding state is not wholly destroyed, but from the point of view of the ceded portion, the original state no longer exists, and sovereignty of a new state comes into existence. So this also proves that sovereignty of a state over any area is not transferred but replaced by another state. Indivisibility is an important characteristic of sovereignty. As sovereignty is an absolute power, it cannot be divided between or shared between different sets of individuals or groups. See, in every state, sovereignty must be vested in a single body and legally competent to issue the final commands. So, division of sovereignty is bound to give rise to inconsistent, conflicting, and ambiguous commands. So, this condition is not compatible to the very concept of sovereignty. But however, the principle of federal state is usually cited as an exception to this characteristic of sovereignty. Because federalism involves the allocation of powers between the federal and the state government, which are regarded as independent and coordinate in their respective spheres. For example, we in India are no less familiar with federal government. We have legislatures and cabinets in the state besides the union parliament and the cabinet. And the subjects of legislation are also divided into union, state and concurrent list. So this paradox can be resolved by making a distinction between sovereignty and power in the legal sense. See, power emanates from sovereignty. Sovereignty vests in the state and power is assigned to the government. Sovereignty is supposed to be exercised by the state and power is exercised by different organs of the government, legislative, executive or the judicial. So the pattern of exercise of power depends on the nature of organization of the government. We describe states as unitary or federal because of different patterns of organization of their government. So basically, these are the forms of government and not the forms of a state. Thus, the federal system represents an extension of the principle of division of powers between the organs of the federal and the state governments, and all of them combine together to constitute a single state within a single sovereignty, absolute, perpetual, all-pervasive, inalienable, and indivisible. See, the division of powers can be evolved or altered from time to time, but sovereignty remains intact so long as the state maintains its independent existence. Now let's discuss different types of sovereignty. Firstly, de jure and de facto sovereignty. So in the case of revolutions, that is a successful overthrow of the existing regime in a state through unconstitutional means, and that is not by the established procedure of replacing the existing government, a distinction arises between the formal and the actual position. Until such time as the new sovereign is legally established and recognized, there may exist two sovereigns, one in the legal sense, who has lost his real powers, and the other in the factual sense, who has not yet been legally established. Therefore, under such circumstances, the legal or formal sovereign is said to retain de jure sovereignty, while the actual sovereign comes to hold de facto sovereignty. Therefore, de jure sovereign may not exercise actual control over a territory occupied by the de facto or actual sovereign, but it continues to be the legal or de jure sovereign over the territory. For example, during the World War II, several European states were overrun by the Axis powers, but the leader of these countries continued to have de jure sovereignty over their respective territories. While the military dictatorship of the present times represents de facto sovereignty until they evolve suitable means to legitimize their authority. See, de facto sovereignty is so described because in actual practice, its commands are obeyed by the people, either maybe because of force or because of a strong following among the people. But it is the de jure sovereignty which is sovereignty in the real sense of the term, and the so-called de facto sovereignty remains inconsequential until it achieves the status of de jure sovereignty. The next type is titular sovereignty. See, in constitutional monarchies such as in England and Japan, the king and the queen or the emperor is officially referred to as the sovereign, and such a ruler is only a nominal or a titular head of a state without any real powers which are vested in different organs of the government according to the constitution of the state. So this form of sovereignty is therefore called titular sovereignty. The next type is legal sovereignty. See, by legal sovereignty, it is meant that the person or body of persons in whom resides the ultimate power of laying down the general principles. See, it is in other words, the sovereign whom law recognizes as sovereign. So, for example, in England, the parliament is legal sovereign as the parliament is the final law-making authority. And the next type is political sovereignty, which is the sovereign that lie behind the legal sovereign. See, while the British Parliament